Session, please be seated.
I apologize for our delay. We are back on the record in our final case of the day, 2022 P422, John HUGO versus Beth Israel Deaconess Medical Center.
Good morning. I am the appellant, John HUGO.
Could you just tilt the mic up a little bit? It's directional. Yes, thank you.
Yes, my name is John HUGO. I am the appellant, and understand that you've read my brief and my reply brief, and are probably familiar with all of the circumstances. This concerns principally the fact that I never received a notice from the court from Judge McCarthy Neiman, her order that would allow additional time for me to file the request for a reduction in bond premium. And typically I had received notices from the court by U.S. mail, which is what I was expecting in this particular case. And
Sir, the record shows that email is a working email, correct? You use that same email to communicate with counsel.
My email has been working for years, and I was about to say defendant's counsel made the point that, well, those notices were sent electronically. And I had never received anything through the years of this proceeding electronically from the court, and the best I could do was to run a search on my computer using the sender's address and me as the recipient, or in the second case, anybody as the recipient that may have been sent to me somehow.
There's also evidence a few days before the deadline, you reached out to, I believe, the clerk and counsel and said you were going to file for another extension. Did you explain that if you weren't aware of the first one?
Well, I was, I knew that there was a 30-day deadline from the date that the tribunal's decision was docketed to either file the bond or file a request for a hearing for the reduction of bond. So I knew that that date was coming up on, I can't remember the date you said, but it's the docketed date was, I believe, November 23rd. So 30 days from then would have made it December 23rd. So I knew that that date was coming up, and that's why I filed the emergency motion for an expansion of time on the 22nd, I think it was, and Judge McCarthy Neiman approved that order the next day, the 24th, but that's the fact, that's the principal issue, that I never received her order, never received a copy of that order. So I was unaware of two dates. One was my proposed extension to January 24th that I had suggested, and the other was the January 11th date that I was supposed to send the brief to opposing counsel. So that's...
So just for clarity, though, did you receive a ruling one way or the other granting you until January 24th, 2022 to file your motion, or is that not what happened?
Well, I didn't receive the notice from the court of Judge McCarthy Neiman's order, which would allowed additional time for me to file the request for a reduction in the bond premium.
Right, but that's what I don't understand. It seems like you did get some additional time, and you have this habit of waiting until the last minute, and if you had filed your motion for the additional time, and if you had just acted within the time you sought, you would have met all of the rules, but you kept waiting for a ruling rather than acting consistent with what you asked.
No, I think I should make my 3 points before we get into some of the details. The reasons for my failure were a series of medical problems, serious medical problems. Several have been ongoing throughout this case for years, but the principal event in December was that I herniated a disc in my lumbar spine. It was sometime in early December. It was shortly after the tribunal hearing was concluded. In addition, I had been having a lot of problems with my molar teeth, and one of them...
Just clarify one moment, these conditions you're describing now and you set forth in your motion, were they ever averred to under oath?
No, I mean, I requested a hearing with Judge Liu for reconsideration, which I made the point in my brief that I would have made the disclosures at that hearing, but I did inform the court clerks by email that I was having problems with medical issues. So, but under oath, I don't, to answer your question, no.
There was no sworn affidavit, there were no supporting documents?
Well, I submitted an affidavit when I filed the appellate brief, and I believe I covered the medical issues in that. I attached a whole raft of calendar dates showing which doctors I'd gone to see, and if there was information in those. The printout comes from the EPIC service that the hospitals and the doctors use. So it may have referred to something specific in terms of my condition.
Can I ask you, the offer of proof that was before the tribunal is not in the record appendix, correct?
Geez, I don't know, but the offer of proof with respect to Dr. Glazer was allowed by the tribunal.
Right, but the offer is to these defendants.
Pardon?
I'm trying to drill down as to what your theory of liability is against Dr. Campbell and physician's assistant Stone.
Yeah, okay. Well, first of all, the operation reports that I've read that were generated through Beth Israel Deaconess Medical Center. The first one with respect to Dr. Campbell was written by a resident, Dr. Bustillos, on one day. This was a day or two after my surgery, and it was signed the next day by Dr. Campbell. However, when one reads that operation report, it's vague and inconsistent. It's like the language says, we did this. And my understanding is that there were 3 surgeons in the operating room, but you can't tell who did what, okay? There's the access surgeon who in some of these A-lift spine surgeries, he's the one that opens you up and goes in to the point where he has to move the blood vessels.
You had time, a number of enlargements of time to hire an expert to drill down on that point, correct?
You mean before the tribunal?
Yes, before the offer was submitted to the tribunal.
Well, I did, but I didn't understand that each doctor is viewed as an independent entity, okay? The way I viewed it is this was a team effort. You had an access surgeon who's also a vascular surgeon, and you had a spine surgeon. And the reason that they work together, as I understand it, is if there's some event, some major shortcoming, like somebody cuts into a artery or a vein, then you need the vascular surgeon there to do that repair work. That's my understanding, but I don't know if that's the case for all of these surgeons. Now, in the case of Dr. Campbell, it's possible that he was just a bystander, okay, that he was just there on call if something happened. But the way the operation report is written, it says, as I said earlier, we did this, we did that, we, found this, so-and-so. But without a deposition of Dr. Campbell, I had no idea of knowing whether he was a passive bystander or an active participant. So when the lumbar sympathetic nerve chain was dissected from the anterior part of my spine and moved to the left, along with the aorta and the vena cava, I don't know who did that. I don't know whether it was Dr. Glazer, whether it was Dr. Campbell. And my first thought was, well, why do we have a vascular surgeon there if he's not going to ligate the blood vessels and divide them and move everything to one side. So it's unclear from Dr. Glazer's operation report what he did or didn't do. So that was the reason for the confusion. And hiring an expert to read the operation report wouldn't have revealed any more than I was able to discern. So I thought that, if Dr. Glazer's part of the surgery was found to be beneath the standard of care, that implicated Dr. Campbell and perhaps Dr. Bustillos if I knew what they did. So that was the problem.
So have you made your 3 points?
No.
Okay.
So I don't know whether you want me to go through chapter and verse what the medical challenges in specific were. I think I wrote them up clearly. If you need any more information on that, I'm happy to discuss it. But this was a disaster for me, okay? This was a calamity in the months of December, January, and until the 8th of February when I had a steroid injection that relieved the pain from the disc herniation. But concomitant with that, I had a condition, still have a condition, that's called small intestinal bacterial overgrowth. So as my doctor said to me, which causes bloating and distension, and one can't really differentiate pain from one's intestines versus what might be coming from a lumbar nerve. And I've been under review with various doctors, gastroenterologists, physiatrists, spine surgeons, neurologists, to try to get to the bottom of it, and I haven't been able to get to the bottom of it yet. And the reason I make the point is that when they do this ALIF surgery, the nerves in the abdomen, according to my gastroenterologist at Mass General, are very delicate. And when you move this stuff around, it can get injured. And as a common consequence of this abdominal surgery, adhesions develop, which is scar tissue, okay? And my surgeon at Yale, Dr. Wang, said to me, "Oh yeah, you have adhesions." The
Can I just interrupt you? Not to be unsympathetic to the adhesions or the condition, but focusing you on the procedure. Appellee will argue you filed late. You're moving to reconsider, to appeal the denial of your motion to reconsider, correct?
Yes. So that part of you're not talking about the medical procedure, you're talking about the legal procedure.
Talking about the legal procedure, yes.
Yeah. Well, my requests for additional time were granted, and they're also tied in with my medical condition. And I don't know why that's an issue, because they were granted.
The time was granted, but you didn't comply. The matter was dismissed. You moved to reconsider, and your reconsideration motion is also, again, appellees will argue.
Okay, now I understand where you're going. The issue with the lack of notice was something that Judge Liu, who granted the request by the defendants for dismissal and final judgment, he knew what, I presume, what Judge McCarthy Neiman had written in her order. It was in the docket. I presume he would know that. So when he got the application from the defendants, he says, well, he didn't file the bond on time, and he didn't do anything else to prevent this order. I mean, he didn't respond. The order says no objection by me. But I was hung up because of my medical condition. I virtually couldn't do anything. So, and I made that point in my brief, that I was just incapacitated. And, having the SIBO condition, having back pain, having the tooth extraction, and then on top of that, the herniated disc, it just combined. I had to take narcotics up to 30 milligrams a day, and I didn't think it was reasonable for me to try to comply. That's why I filed the emergency motion for an expansion of time. because I just couldn't do it.
But the one thing we're looking at is the judge has considerable discretion, and
Right.
do they abuse the discretion? And his concerns seem to be, and again, I also don't want to be unsympathetic to medical challenges. As we all get older, we all start to have them, or see close friends who have them. But the judge seemed to think that this was the delay was a pattern by you, and that it wasn't just this short-term period. So why was that an abuse of his discretion?
Well, I think he should have had a hearing, number one. There was no testimony given by me or the defendants. And as I read the law and as I reported in the cases that I thought were relevant, he's required to make findings. He's required to hear testimony to prove that he didn't abuse his discretion. So his supposition, perhaps, that this was some pattern that I was doing on purpose is completely wrong. I mean, I got to tell you that...
Is it wrong, or is it that you're saying there was a pattern, and that's because you had these conditions and therefore frequently were delayed?
Well, it's both. It's that plus the fact that of the instances in the past when I had asked for more time, there was good cause for those requests. It wasn't as if I was trying to delay things. I mean, this case was filed in 2018, okay, and the surgery was in 2015. So we're going on the 8th year right now, and I'd just as soon finish it, quicker. And when we scheduled the trial that came out of the scheduling process, it is December of this year because of defense counsel's previous commitments. And I argued for, well, what if those cases get dismissed or they reach a settlement? Can't we accelerate the date? So I was making an argument to try to make it happen sooner rather than later. It's not me that's causing the delay in that respect.
I'm afraid that time is expired, which is signified by the red light.
Can I make one more point? That indigent persons such as myself should be allowed access to the court system, and I should have the right to file the request for reduction in bond and see what the Superior Court says about that.
Thank you very much. We will hear, I believe, first from Attorney Smyth.
Good morning, Your Honors.
Morning.
May it please the Court, Kelly Smyth for appellee Melissa Stone, PA. She is a physician assistant. Your Honors, the only issue on appeal today is, as you noted, is the denial of Mr. HUGO's motion for reconsideration of the court's allowance of the motion to dismiss filed on behalf of my client and Dr. Campbell. And it is our position that the decision by the Superior Court was not an abuse of discretion. It was not capricious or random. It was in the unique eyes of a judge who was well aware of the long-standing history of this case, the procedural history.
So what,
Much has been made.
if somebody does have a series of health calamities, as is alleged here, what should the judge do?
Well, in this situation, Your Honor, what happened is the plaintiff did file a motion for expansion of time to file a reduced bond. And so, contrary from what's in the papers, defense counsel, we filed a limited opposition. We agreed, yes, you can have an extension. We recognized those issues. We took those into consideration. We appreciated those. And so we said, yes, we'll give you an over 30-day extension to January 24th. We would just ask if you could please serve it to us 9A as something Mr. HUGO hadn't done in the past. So we were asking for that. We took into consideration that, and that's what Judge Liu took into consideration. And so in looking at the statute, here we have 231, Section 60B is very explicit. If you don't win at the tribunal level, if you don't submit evidence that's sufficient, you have to file a bond, and your case will be dismissed. It says shall be dismissed. And so despite the fact that Mr. Hugo had unprecedented opportunities of being granted a second bite at the apple by submitting an offer of proof, correcting his initial offer of proof, which failed to include an expert letter, he still did not include an expert letter as to the care provided by my client, a physician assistant, or Dr. Campbell. And
So, this may be a little bit afield, but his response is, well, your client has created this situation by not writing a report that clearly delineates what each person did in the procedure. So how's he or any member of the medical public supposed to deal with that?
Respectfully, with regard to my client, a physician assistant, she's not actually participating in the surgery, but to answer your question, it is the responsibility of that party moving to bring a medical malpractice case against medical providers to have justification. That's the reason why we have the 231 Section 60Bs to prevent these frivolous actions. And so,
Right, but his response, and really any other patient's response, is going to be, are you kidding me? You, the medical provider, aren't telling me who did what. So how am I supposed to do that?
So what happens here is you retain an expert. You can retain a vascular surgeon or a surgeon who can actually look at the entire record.
Again, that takes a ton of money. Why aren't we saying to the medical profession, you need to write a report that's very clear about who did what? Like, I mean, that's kind of 101 about how you serve people.
Absolutely, and there is a report that was drafted
Says
by
we.
Dr. Glazer. And
If he's right, I don't know whether he's right or not, but I mean, I've seen some of those reports myself. They say we, and I'm like, how are we supposed to, how are we, the rest of the public, supposed to figure out what that means?
In this situation, Your Honor, Dr. Glazer did write an operative note, and notably, the case remains pending as to Dr. Glazer and Boston and Beth Israel Deaconess Medical Center. And so you'd be given an opportunity to take their depositions, but also if you must have that expert letter, you cannot go ahead and proceed with a case against a medical provider without justification. And with respect to the notice issue, as Your Honor had indicated, here he was asking for an extension. So until he's asking the court to grant him
And he
something.
got that extension, right?
Actually, no. He filed an emergency motion for further time to file a reduced bond. That was on December 20th or 21. And so until you get a confirmation from the court that your request has been granted, you know what, you can't, that deadline is looming and you must comply with it. So the onus is on the party asking for something from the court to call up, to find out, to check that docket. That was his burden. In addition, when he wrote that email of January 20th, 4 days before the deadline, which Mr. Hugo indicates he wasn't aware of, it's important to note, as Your Honor had noted, that there's nothing in that email to indicate what is the status of my original motion for extension of time. Did you allow it? Should I ask for another one? What shall I do? It's not in there. There's nothing about the status of his initial motion for extension of time. And what he's asking there is, I have been unsuccessful in making progress on the motion, the moving paper, so I'm going to make another request. You wouldn't ask for another request unless you didn't know that your first motion was denied or not, or granted.
So you think he knew it was not granted, and that's why he was announcing he was going to make another request?
It is my position that his statements that he was not aware of that notice of self-serving, but based on this email, but nevertheless, even if it is the position that he didn't receive that notice, the burden was on him to make sure that that looming deadline was complied with, or that the court took action on it. In addition, the fact is, when Ms. Stone and Dr. Campbell filed a motion to dismiss on January 25th because, again, there was never a bond posted as required or that motion to reduce the bond. And notably, there was no opposition to it.
And you had served him previously?
well, excuse me.
Had you served him previously?
Yes, and as in these in the briefs, Mr. Hugo is not saying that he didn't receive notice of our motion to dismiss.
And are you arguing the operative date of the judgment is February 9th?
Yes,
You're not advocating for January 27th? I don't know that it makes any difference, but
correct, it doesn't, because that appeal is still late. He filed on March 14th, and the appeal should have been filed on March
But
11th.
there couldn't have been an appealable judgment until the 54B certification, correct?
Yeah, the judgment entered on, the separate and final judgment entered on February 9th of 2022.
Just one question. If under our authority, we did find non-protonc that he did reserve his right to appeal the dismissal, what is your position?
There are no merits on this case because we go back down and he has to file a motion to reduce the bond. In this situation, because he didn't submit an expert letter that talks about at all about my client's care or Dr. Campbell, what happens is, given the fact he is indigent, that does not relinquish, that doesn't guarantee that he'll have a reduced bond. In fact, the courts are clear that they can increase this bond where there's not a good faith basis.
But the issue would be the dismissal, the court's dismissal, not about the bond. The court didn't reach the bond issue. It's the dismissal of the, it's 54B based on the medical tribunal's finding. So we'd be reviewing that.
You would not be reviewing the decision by the, if I'm understanding your question, you would not be reviewing the question about the offer of proof and the tribunal's decision. That is not on appeal here. It's just the denial of the motion for reconsideration.
Are you saying that we could not affirm on that ground? Were we to look at the offer of proof and conclude that it doesn't support a claim, we couldn't affirm on that ground?
Well, in looking at the abuse of discretion standard, certainly within the panel's discretion to look at the merits of the case, and there are cases cited to that, and so the merits would include, wait a minute, did he submit that expert letter that is required, and he hasn't.
But it wouldn't be an abuse of discretion review.
I'm sorry.
It would not be an abuse of discretion. Did you say it'd be an abuse of discretion review of the merits of the dismissal?
I'm sorry, no, it would not be an abuse of discretion by this panel to decide the merits, whether or not there's a meritorious case. That has to be part of the consideration.
I mean, isn't your argument somewhat different from Dr. Campbell's in that whatever else is true, your client was not performing the surgery, and therefore it doesn't get swept into we?
That is true, Your Honor. My client was not participating in the surgery, but also that expert letter that Mr. Hugo submitted with that second offer of proof was literally silent as to Ms. Stone.
Standard of care for a physician's assistant.
And also Dr. Campbell.
We will hear from Dr.
Thank
Campbell's
you.
counsel.
We would ask that you uphold and affirm the decision of the Superior Court. Thank you.
Your Honors, thank you. May it please the Court, Nicholas Murnier on behalf of the defendant, Appali, Dr. David Campbell. I would start perhaps with this issue that we're talking about and that Your Honor brought up about the operative report, because I don't think, I think our position is quite synonymous with Ms. Stone's opinion. I think we're similarly situated in this appeal, but just to address that, that argument. First of all, that's not an argument that's made in the brief that Mr. Hugo was unaware that he was confused about the operative report and he was unaware that he needed an expert specifically to talk about Dr. Campbell. That's not in the record appendix, it's not in the brief. But just to address it, Dr. Campbell's operative report, I mean, I would argue is not vague. Operative reports are somewhat, they use a lot of medical jargon. They may be hard to distinguish for a layperson, but that is the function of an expert. And Mr. Hugo does have an expert in his offer of proof. He has an orthopedic surgeon who had the opportunity to review the records, and in doing so, makes no comment, does not mention Dr. Campbell's name at all in outlining his allegations of negligence against Dr. Glazer, the orthopedic surgeon who did the spinal surgery, completely silent as to Dr. Campbell. And that's not Mr. Hugo having to review the records. That is an expert that he has retained who has reviewed the records and says nothing about Dr. Campbell's role in the case, or Dr. Bustillo's role in the case, or vascular surgery in general and their role in the case. And that's an orthopedic surgeon who arguably is familiar with the standard of care that's required for this type of surgery that Mr. Hugo underwent. But I think the focus really should be, and I would essentially adopt all of my sister's arguments and maybe just continue them, is that this is an abuse of discretion case. What's on appeal here is Judge Liu's denial of the motion for reconsideration on final judgment, 54B judgment that was entered. So that I would argue makes it a Rule 60B motion, a motion to vacate judgment, and an abuse of discretion standard.
So let's say that a party does have a series of medical issues that it's just taking them a few months to get under control. Where we have generally a policy in this country of accommodating disabilities and illnesses, what should the judge be doing?
Well, I think as my sister started to outline, the facts in this case, even if we're just looking at the last few months from December onward, I don't think alleviate the issue that we're presenting here. You know, the tribunal entered their finding on November 22nd, and it was not until, so the bond would have been due by December 22nd. On December 20th, Mr. Hugo filed an emergency motion. Now, I would argue that he could have simply filed the motion to reduce the bond at that point in time. He needed to file something. He could have filed the motion to reduce the bond at that point, but he spent the time filing an emergency motion to get an extension. He was granted that extension in collaboration, and the emails between Mr. Hugo and us are in the record appendix, in collaboration with us saying, we acknowledge your medical issues, we have no problem extending the deadline to a certain extent, not forever, and that was submitted to the court. They gave him until January 11th to file via 9A, which is something that he had never done. We asked him to do so because the court prefers it, and then to file the motion by January 24th. Nothing. We got an email, which Ms. Smyth talked about on January 20th, saying, I need to file another request for expansion of time. So again, even if he hadn't received the notice from the court on Judge McCarthy-Nyman's extension of time, he was aware that something still needed to be filed. And he could have used that opportunity to file the motion to reduce the bond. You know, at any of these points in time, even if he was experiencing some medical issues, which we acknowledged and gave him some understanding on, he could have used that time to simply file the bond or file a motion to reduce the bond. But it then continued. So so he had until January 24th to file something. Nothing was filed. January 25th, Dr. Campbell and Ms. Stone served a motion to dismiss via 9A and for separate and final judgment. While that was pending under 9A, on January 27th, the court dismissed the case, sua sponte. Once we got no opposition via 9A, that's another opportunity that he could have filed something with us, with the court. On February 7th, we filed our motion for separate and final judgment with no opposition. The court allowed the motion on February 8th. Judgment entered on February 9th. It was not until February 23rd that Mr. Hugo filed his emergency motion for reconsideration. So this is what Judge Liu is picking up on when he denies the motion, and I won't go through all of the dates prior to that, but I do think they are relevant. Mr. Hugo, in his reply, argues that it was inappropriate for the defendants, the appellees, to suggest that the cumulative nature of these delays is not relevant to what Judge Liu was deciding, but I would argue the exact opposite. It is very much relevant, and that's what Judge Liu was speaking to when he says in his denial of the motion to reconsideration that this will go on and on, because it had gone on, and Mr. Hugo had been given numerous opportunities. So when you look at to file an offer of proof, with an expert letter, and then in this most recent situation, to file a motion to reduce the bond. You know, when the Berube case, which I think both of us cite, you know, it says the judges in the motion session are in the best position to assess weighing litigant rights to be in front of the court and the opportunity to be in front of the court with efficient and appropriate case
May I
management.
interrupt you because you both do address that, and
Yeah.
that issue is clear before us. But we don't have a lot of time to discuss whether we can get to the merits of the judgment, so grant me that we can. What is your position? We review it as if a directed verdict in light most favorable to the plaintiff, and there would have to be an offer of proof that substantiates the burden. What is your position on that?
I mean, the plain fact is that over the course of 2 years, there has not been an expert letter that substantiates allegations of negligence against Dr. Campbell. So the offer of proof was clearly deficient, and if this case was remanded, I think it's appropriate to consider that, but if it was remanded, then as Ms. Smyth outlined, we would be in a position to oppose a reduction in bond and to likely ask for the bond to be increased for the fact that there is no expert letter and has never been an expert letter as to Dr. Campbell.
So just to be clear, a motion to reduce the bond was never actually filed?
It's never been filed.
Nor an affidavit of indigency.
Correct. We've never gotten to that stage. Although my argument to you today is that that could have been done. Rather than simply asking for more time, he could have filed the motion. Thank you. I see my lights blinking, so
Thank you all very much. The case is submitted. This concludes our session today. Our thanks to the court officers and the clerks and law clerks, and we are adjourned.